On behalf of the committee, I welcome everyone to this public hearing into the Territory Coordinator Bill 2025. I welcome to the table to give evidence to the committee from the Department of Chief Minister and Cabinet, Mr. Tom Leeming, Deputy Chief Executive Officer Policy Reform and Regions, Margaret Close, Senior Executive Director Strategic Policy and Delivery, Stuart Knowles, Interim Territory Coordinator. Thank you for taking the time to come before the committee today. We appreciate you taking the time to speak to the committee and look forward to hearing from you today. This is a formal proceeding of the committee, and the protection of parliamentary privilege and the obligation not to mislead the committee apply. This is a public hearing and is being webcast through the Assembly's website. A transcript will be made for use of the committee and may be put on the committee's website. If at any time during the hearing you are concerned that what you will say should not be made public, you may ask that the committee go into a closed session and take your evidence in private. Can you please each state your name and the capacity in which you are appearing?
My name's Tom Leeming. I'm the Deputy Chief Executive Officer of the Department of Chief Minister and Cabinet for Policy Reform and Regions.
Stuart Knowles, the Interim Territory Coordinator within the Department of Chief Minister and Cabinet.
Margaret Close, Senior Executive Director, Strategic Policy and Delivery at the Department of the Chief Minister and Cabinet.
Thank you. And before we begin, I'd like to acknowledge my fellow committee members that are here today. We have the member for Gwoja, Mr. Chansey Paech, the member for Drysdale, Mr. Clinton Howe, the member for Johnston, Justine Davis, and the member for Wanguri, Ms. Ollie Carlson, is joining us via telecommunications. I'm Andrew Mackay, the member for Goyder. Mr. Leeming, would you like to make an opening statement?
Yes, please, Mr. Deputy Chair. And thank you for the invitation to speak to the committee today about the Territory Coordinator Bill. I'd like to begin by acknowledging the Larrakia people as the traditional custodians of the land that we're meeting on, and pay my respects to elders past, present, and to emerging leaders. I also want to recognise the important role that traditional owners play in the Territory's economic future. I hope this brief introductory statement will answer some of the questions you have about this bill, its purpose and the Territory Coordinator role. As background, we were asked by government to develop legislation that would deliver on its policy objectives of coordinating and streamlining regulatory processes for significant and complex projects and developments that have the potential to drive economic growth and accelerate private sector opportunities in the Territory. So the policy intent is to boost the Territory's competitiveness to attract large-scale investment to fuel growth and create jobs for Territorians. That's the policy instruction we were given by government. On the consultation process, I know it's been the subject of some discussion. There has been extensive consultation in the development of this bill. That was summarised in a consultation report that was published on our departmental website on the 12th of February. That consultation included targeted consultation with government regulators, with private sector proponents, with industry peak bodies, with land councils and with other stakeholders on the broad model and framework for the Territory Coordinator. It included the publication in October of a consultation paper which outlined key aspects of the proposed model, and included the publication of a draft Territory Coordinator Bill and a guide accompanying it in November, which also coincided with the announcement of Stuart Knowles as Interim Territory Coordinator. So we had an over 3-month period of consultation, and in that time we had, as a department, and in collaboration with some of our partner agencies, including the Department of Mines and Energy that you've just spoken to, we had 89 stakeholder consultation meetings, which touched 267 participants in those meetings across a range of stakeholders, including peak bodies, industry leaders and community groups. We received 559 written submissions, about half of which were unique individual submissions and the other half were standard form campaign submissions. We held, my colleagues here held 6 community information forums across the different regions of the Territory. 321 people attended those. We got 81 feedback forms about them. So this was an extensive consultation process over more than 3 months, and the feedback that was generated through that process has informed a number of relevant refinements to the bill that is before you now. And we really want to thank everyone who took the time to provide their views on the bill and engage in the process. We were really pleased with the level of engagement we got as a department in that process, and of course we welcome the opportunity for further scrutiny through this committee process. In terms of the bill itself, just to give the high-level outline of how we have designed the bill to deliver on the government's policy intent. So the bill, as you know, establishes the role of the Territory Coordinator as an independent statutory officer. The bill sets out the eligibility requirements for that role, the terms and conditions of appointment, and the mechanisms to terminate appointment. It provides for a range of functions and powers of both the Minister for Territory Coordinator and the Territory Coordinator, and it also makes clear that all public entities need to cooperate with the Territory Coordinator. The main kind of mechanisms by which the bill works, the core framework of it is that it allows for the designation of three things: significant projects, programs of work, and territory development areas. Also associated with significant projects is infrastructure coordination areas, and associated with territory development area plans. The key features that I'd highlight, one is primary principle, and I'd point out that the primary principles guides both the Minister and the Territory Coordinator in exercising the key powers under the Act. That requires those decision makers to consider the primary objective of economic development, but as well as the potential social and environmental outcomes. So it requires consideration in all decision making under the Act of all three. The second key feature is that when those three things are designated, significant projects, programs of work, and territory development areas, and a toolkit of powers are enlivened for the Minister and or Territory Coordinator to support projects and developments of economic significance, to coordinate and streamline complex regulatory processes. So the key powers, there's the three request powers and three notice powers, which are the key powers. The prioritisation request is to request a public entity to prioritise a specific statutory process. The progression-related request is about requesting a public entity to start or complete a specific process within a specified period, or to pause, or to restart. Decision request is a request of a public entity to make the statutory decision within a specified period, so putting a real time limit on it. And then the notices are condition variation notices, varying the conditions imposed on approval, a step-in notice to a public entity advising that the Minister or Territory Coordinator will step in to take the statutory process on behalf of that entity. All of those powers are, in certain circumstances, able to be exercised by the Territory Coordinator. There's one of those key powers that can only be exercised by the Minister for Territory Coordinator on the advice of the Territory Coordinator, which is the exemption notice to a responsible entity, which excludes or modifies the application of a relevant law in specific circumstances. We've designed the bill and drafted the bill to make sure that all of these decisions are made in a responsible and transparent way that is open to scrutiny with appropriate checks and balances. So there's a number of safeguards that we've put in the bill that I'll highlight, and I'd point out that a number of these safeguards have either been introduced or strengthened based on the feedback we received on the draft consultation bill. So those powers, those key powers that I've talked about, one safeguard is that they can only be used when an area has been designated as a significant project, a programme of work or a territory development area. They can't be used generally on anything. They can only be used once the designation has been made. Before any decision is made or recommendations put forward to the Minister about exercising those powers, the Territory Coordinator has to consult with the responsible regulator. So I think this has come up in some of your questions today, but the responsible entity for that decision has to be consulted before the Territory Coordinator or the Minister can make a decision. They're not making it on their own without any advice or input from the underlying decision maker. The bill says that they have to consult with a responsible regulator before making a decision. The Territory Coordinator has to report to the Minister on all requests and notices made within 5 business days. All reports on step-in, condition variation, exemption notices have to be presented to the Legislative Assembly. So none of those notice powers can go unexamined. On exemption notice, the disallowance provision allows the Legislative Assembly to veto exemption notices. And the bill mandates that all necessary notifications across all of those key powers are available to the public. So there's transparency. Decisions made by the Minister have to come with a clear statement of reasons, so that every step of the process is visible and ensures that all stakeholders understand the rationale behind a decision and can see the line of sight from what's in the Act to the bill now, but the Act when it passes, to the decision that's being made. And the last important safeguard I mentioned, because it has come up a fair amount over the last 2 days for you, is that the powers in the bill cannot override Commonwealth laws. That's a basic fact of our constitutional order in the territory. Any exercise of powers in the bill that aren't consistent with Commonwealth laws would be an invalid exercise of power and would be overturned by a court. So this includes Aboriginal land rights and native title rights and interests, which are protected by Commonwealth laws. So to the extent that the rights and interests of Aboriginal people, particularly traditional owners and native title holders, are protected by Commonwealth laws, there's nothing in this Act that can override or undermine those rights and interests, because nothing in a territory law can override or impede with the exercise of a Commonwealth piece of legislation. So there is nothing in this Act that can override Commonwealth laws, because there's nothing in any territory Act that can override Commonwealth laws. So I'll just mention in closing, a few of the other changes to the bill we've made in response to the voluminous feedback we received. We made some changes to the schedule of acts to which the key powers can be exercised. We removed the Nuclear Waste Transport, Storage and Disposal Prohibition Act. We added the Heritage Act. We've expanded, based on feedback from a number of stakeholders, including land councils, we expanded the definition of interested party to include references to registered native title body corporates, registered native title claimants, and representative Aboriginal and Torres Strait Islander bodies under the Native Title Act. We amended the definition of owner-occupier to include relevant traditional owners and persons with registered native title rights and interests. More broadly, we provided more clarity in the current version of the bill around the purpose and operation of programmes of work, and we revoked the time limit on a territory development area designation so that it can remain in effect until it's revoked. So, in concluding, this bill has been drafted to support streamlined regulatory processes to expedite those projects that will deliver significant economic benefit to the territory. And I and my colleagues, Margaret and Stuart, would be very happy to answer any specific questions you have about the bill and the Territory Coordinator role.
I have 2 questions and I'll pass over to the rest of the committee. My first question, you touched on it a little bit in the opening there. Today we've heard from a number of land councils and throughout this process from traditional owners as well about their concerns regarding the Territory Coordinator's powers in relation to Aboriginal land and sacred sites and the protection of their history and culture. I was just wondering if you could elaborate again how in their submissions to, I assume, the initial bill as well, have these concerns been addressed?
Thank you, Deputy Chair. Both recommendations and issues raised in formal submissions, but also recommendations and issues raised in the several meetings we've had with each of the main land councils on this topic. I'll go back to where the point I made during my opening statement, that there's nothing in this legislation, nor indeed any territory legislation, that can undermine the rights and interests of traditional owners and native title holders under the Aboriginal Land Rights Act and the Native Title Act, because as a basic principle, there's nothing in territory legislation that can overrule or undermine rights that are enshrined in Commonwealth law. There's 2 ways in which then the Aboriginal rights and interests as enshrined in Commonwealth legislation are protected. One, the schedule of acts at the back does not allow the Territory Coordinator or Minister to exercise powers in relation to the key NT acts that relate to Aboriginal rights and interests that interact with Commonwealth legislation. So particularly the NT Sacred Sites Act is not on the list of scheduled laws for that reason, and nor is the Aboriginal Land Act. The NT Aboriginal Land Act is not in the schedule for that very reason. So the bill doesn't allow the Territory Coordinator or Minister for Territory Coordinator to exercise powers in regards to those acts, but also the bill can't allow for the territory coordinator or Minister for Territory Coordinator to exercise powers in a way that overrides those rights and interests enshrined in Commonwealth legislation, because you can't. That's the way our constitutional order works in the territory. That's the way the territory is established as a territory. So there's two lines of protection there, very fundamental lines of protection for Aboriginal rights and interests as enshrined in Commonwealth legislation, and that's one of the key reasons that what was previously in Section 14 of the previous consultation draft bill isn't there anymore. It's just simply not necessary because we've got those other two layers of protection for Aboriginal rights and interests.
Thank you. And my other question is, there's been a lot of discussion throughout this public hearing relating to the states that have similar measures in place and similar bodies, such as Queensland and South Australia are the two that have been coming up time and time again. When drafting this legislation and in presenting it, what consideration was given to how they implemented this kind of measures in their states, and then, what lessons, I guess, have been learnt from the way that they've done it to make sure that this is the best piece of legislation to achieve this goal?
And if I may, I'll answer the question at a high level, but I know Mr. Knowles has been extensively involved in some conversations with people in the jurisdictions, as has Ms. Close. So I'll throw to them for further detail. But we have certainly drawn extensively since the very beginning of this process from experience and legislation and expertise in other jurisdictions. Across various people in our department, we would have spoken to the people that do the Queensland Coordinator General model 5 or 6 times, including a couple of times in person in Queensland. We've had many conversations with the South Australians, who are almost exactly in parallel with us in terms of developing their legislation. Had a number of conversations with the Western Australians who are in caretaker right now, but are considering a similar model. And there have been certainly interactions with the other jurisdictions about what they're doing, and a lot of research into what their legislation does and how it operates. The summary of that would be what we're doing is most similar to what South Australia are looking to put in place. It certainly draws on the long-standing experience in Queensland, which I'll ask Mr. Knowles to talk about. And to a lesser extent, we've drawn on the similar, in some respects, models that are in place in New South Wales, Tasmania. And we're aware, as I said, of the Western Australians beginning to think about this kind of model, and Victorians thinking about this kind of model too, although that's less clear to us at the moment exactly what that will look like. We've also looked at the international experience. Most jurisdictions across Australia and the world are coping with the same issue, which is over the years, jurisdictions establish a range of legislation, including regulatory instruments, to protect and deal with specific issues, and those pieces of legislation are generally high-performing on their own merits in their own space. The issue is that there is a compounding impact of all of those bits of legislation and regulation, which, when put on top of each other and applied to a complex and large project, create a collective regulatory environment that is prohibitive and uncompetitive in terms of that jurisdiction attracting investment. So it's not necessarily anything wrong with a particular piece of legislation or a particular piece of regulation. It's the compounding effect of these big complex projects that might be subject to 10, 15, 20 pieces of legislation and 20, 30, 40 regulatory processes under those bits of legislation. It's the compounding effect of all of those together, which has led jurisdictions to the same point that we are at, which is we need something to be able to streamline and coordinate across for the bigger projects which face that real compounding of complexity and time associated with layers of legislation and regulation. But I'll ask Mr. Knowles, who's had more direct conversations with some of the other jurisdictions, to comment.
Yeah. Excuse me. Thank you, Tom. Just to provide the context, I started in the position on the 25th of November. So I've had involvement between the original draft bill that went out for public consultation and the final bill that's been tabled in Parliament. But as a part of that consultation piece of work that we focused on over that November, December, January period, I did travel across to Queensland and I met with the current Coordinator General over there, and I met with a previous Coordinator General in Queensland to discuss our bill and to discuss the Queensland experience over many years since 1938, since they've had a Coordinator General piece of legislation in place. Following that, I went to Adelaide and I met with the Department of Premier and Cabinet in Adelaide in relation to their draft bill, which they're intending on their last report to introduce into Parliament in March. So the conversations were different in that respect because South Australia was still developing their bill, so they were more interested in the work that we had done. But Queensland, it was really understanding what their lessons learned have been over the years, how the different Coordinator Generals have gone about exercising those powers. And that then fed into some of the amendments that were made in the bill that was tabled in Parliament in February.
Mm-hmm.
Thank you. I'll pass over to the member for Gwoja.
Thank you.
And I would just ask that you
Chair.
do one question at a time.
I've got 3 questions, but I'll let you respond to each of those at the appropriate time. The first question is, we have had independent legal advice, which has raised concern with Clause 18 of the bill. And you may have heard me talk about that previously. That's about the role of the Territory Coordinator to delegate their functions and power to any person who the Territory Coordinator is satisfied has the appropriate qualifications or experience. Under the Northern Territory Interpretation Act, that's very broad, and in your draft bill, there is no provision or clarification that the Territory Coordinator couldn't delegate that to a entry-level staff member. What safeguards are in place?
Thank you, Member for Gwoja. The first and most important safeguard that's in place is subsection 2 of Clause 18, which is that the powers or functions under Part 7, which is all of the key powers, cannot be delegated. So none of the powers associated with notices, so progression notices, etc., or with the request notices like prioritisation, progression and decision, and the notice powers, including step-in, exemption and condition variation, none of those powers can be delegated. The only powers and functions that can be delegated are the broader powers and functions of the Territory Coordinator, which relate more to coordination and getting information from agencies and consulting with agencies and so on. So none of the key powers can be delegated.
They have to sit with the Coordinator.
Yes, that's certainly my reading of Section 18 of the bill.
Okay. And further to that, you make mention following the consultation, you remove the provision around the transportation of nuclear waste. Again, subject to independent legal advice, raises the concern that the schedule can be updated by regulation, so there is no ruling out that the current government or a future government cannot just amend regulations and include the transportation of nuclear waste, correct?
Correct that the schedule can be updated by regulation.
Yep. So the nuclear waste provisions could be just amended by regulations not needing to be addressed on the floor of Parliament, correct?
Yes, the schedule of acts at the back can be updated by regulation.
By regulation. And further to that particular question, you talk about the Aboriginal Areas Protection Authority legislation. Just a point of clarification, not all sacred sites are only on Aura. There are many sacred sites in areas of the Northern Territory that is not on Aboriginal lands. So there's nothing stopping the government from later amending the regulation to put the Aboriginal Areas Protection Authority's legislation on the schedule through regulation, correct?
To the extent that your question is, could another act be added to the schedule? Correct.
So the sacred sites legislation could be added to the schedule by regulation.
Sorry, could you repeat that bit?
The Aboriginal areas, sacred sites legislation, could be added to the schedule by regulation.
Any piece of NT legislation could be added to the
Right. So
schedule
the
by
entire Northern Territory statute could eventually end up being a matter for the Territory Coordinator by regulation.
Correct.
Right.
Margaret, did you want to add to that?
Margaret Close, a Senior Executive Director, Strategic Policy and Delivery. So Nuclear Waste Act, the Transportation of Nuclear Waste Act, could be added back on, but we removed it after feedback from the public and reviewing it again that there was actually no need, there was no powers that the Territory Coordinator would need to exercise in relation to that act. So yes, it could be added back on, but I think the decision has been made that there is no kind of benefit to being gained for having that on there.
Thank you, Ms Close. The question is, though, based on the consultation, was there not an appetite to put a list of pieces of legislation that were raised through the consultation as areas of concern, the transportation of nuclear waste, the sacred sites legislation, Indigenous protected areas, local government, to be listed as items that could never go on the schedule and never go through just regulation to be on there?
The approach has consistently been that we have a schedule that can be amended by regulation, in part because we don't know what we don't know about interaction of legislation with projects 20 years down the track.
Sure. I acknowledge that's just obviously wanting to just confirm. We've heard from people from your consultation process that that was an area of concern and that following those consultations that had happened. Look, the question that I did have was particularly around Mr Leeming, you talk about extensive consultation. I vehemently disagree that your process was extensive, and I want to confirm that it was done over November, December and January, when many Territorians are either on vacation or they are to leave with families. There is the wet season. Access to regional and remote communities is restricted. How many of your consultations were done in remote communities and how many were done in language?
There were several elements to that question. I'll go back to the first one, which was, can I confirm when the timeframe was? Yes, the timeframe for consultation was, I think we started in October and ran through till 17th of January. So yes, the consultation took place a little bit in October, over November, December and most of January. Physical consultations in terms of the community information forums that were held in each of the main regional centres of the Territory.
So no remote communities were consulted through a travelling roadshow?
There were no physical... There were no consultation sessions physically held in remote communities, no.
And were any materials as part of your consultations done in First Nations language?
No.
Do you think that's a problem?
I don't think I'm at liberty to comment and make...
I'll rephrase that. Did the department at the time of the consultation process consider using the Aboriginal Interpreter Service or external Aboriginal media organisations to help communicate the messaging around the Territory Coordinator?
Not to my knowledge, no.
Thank you.
Sorry, the member for Johnston has a
Sorry, just a couple of follow-up questions on that. Thank you, Clinton. Thank you for outlining the consultation process. I've just got a couple of, I guess, data questions. We haven't seen the submissions from the original consultation process. It's very difficult to know what they actually said from the report that was produced. The language that's used in that report is very vague and broad, with words like many and few. Would you be able to share with the committee how many of those submissions were in support of the bill and how many were against it?
Well, there's a few parts to that question again also. We haven't published the various submissions we got about the bill because we don't have the consent of the people that made the submissions
Sure.
to publicly release them. That's why we haven't publicly released them. In terms of the number of submissions that were supportive and so on, there were a lot of submissions where, whilst many of the submissions it was possible to discern support or opposition to the legislation, for a significant number, it was the nature of the submission was comments and recommendations on the bill, which could be construed as supportive or not supportive.
Okay.
There's no objective way of doing that.
For the member for Johnston to get the information, could we potentially get on notice a question, and then we can get all that information instead of kind of
Yeah, we
juggling
don't
through
need
it?
to go into detail now, but I mean, I guess just based on the feedback that we got from this consultation, where they are public, 95% of there was a very clear view from the community and stakeholders. So I'm just wondering if that was reflected in the initial consultation that we haven't seen. I'm happy to take that on notice, and if you could provide whatever information is.
We can endeavour to provide the information. I mean, what I would say is the consultation process and the way that we synthesised the consultation that came in, including in the consultation report, was designed to do two things. It was designed to inform people, inform Territorians of the bill and what was in it, and it was designed to elicit recommendations about how the bill could be strengthened.
Thank you.
It
And I'm
wasn't
particularly
designed to be a
interested.
plebiscite on the popularity of the bill.
I'm particularly interested in the second part of that, and what recommendations were taken on board from who in relation to the two versions of the bill, and I'm wondering if that's information that you could share.
That is certainly information we can share, but it's a long list, so that will need to be.
If you can take that, would you like
if
to
you could take that on notice, I'd
notice?
appreciate it. Thank you.
Thank you. I've got a few questions. The first, I'd like to, a major concern we've heard over the last 2 days is environmental concerns. And so I'm just very keen to hear how is the department addressing those and how are they ensuring environmental safeguards and protections will still be met?
It might be helpful if you were to be a bit more explicit about the nature of the concerns that people.
So just like there's been general, like the environmental, there's been large environmental concerns with the bill. I'm just keen to hear how the Territory Coordinator, working with the departments, basically is ensuring that we're still meeting environmental safeguards that currently exist.
Sure, and I'll pass to Mr. Knowles in a moment to talk about what his approach to it would be. But that's a bit of a hypothetical because it depends on whether the bill's passed and how the appointment's made. In terms of environmental protection and protections enshrined in any regulatory legislative setting that we have in the Territory, this bill doesn't change those legislative and regulatory settings that we have at the moment. What it does is provide a toolkit to the future Territory Coordinator and Minister for Territory Coordinator to coordinate and streamline those legislative and regulatory settings.
So just to reinforce that point, the Territory Coordinator is not changing any current environmental regulations.
No, and nor can the Territory Coordinator in future change any environmental legislation or regulations. The Minister may, on the recommendation of the Territory Coordinator, consider exempting certain provisions of certain acts in certain circumstances with a range of safeguards around it for a particular project to streamline the approvals processes for that project.
And so
But at no point in this bill are we changing the underlying.
And so when that happens, that that final approval is by an elected member.
In the
minister.
final approval of
So
in the case of an exemption power.
Yeah.
In case of the exercise of an exemption power, which is the only bit of this that changes the application of an existing piece of territory legislation, it is only a minister that can make that decision, and that decision is subject to disallowance by Parliament.
Fantastic, thank you. Stepping out of that, when you were speaking about other states, obviously we heard today a concerning figure of some of the low rates we're getting of, especially with mineral projects getting through. And I think what's clear is, I have my opinion that it seems to be a uncompetitive environment, especially comparing to other jurisdictions. Could you please give your thoughts on where we currently sit, and with this bill being introduced, how will we be more competitive, especially in the Australian environment or even in the world environment, and creating a framework for investment?
Sure, I might pass to Mr. Knowles, who can answer that question better than me.
Yeah, so one of the, and with the other experiences around Australia where similar models are in place, one of the key factors in making final investment decisions on large-scale investments is certainty around approvals and timeframes to get them. That's really where this legislation can provide that certainty to investors, and remembering that this is only going to be available, the toolkit will only be available on the designation of a significant project in the case of a mine or a territory development area or a program of works. But if you're talking about a mine of a large scale that's providing jobs, it's providing business opportunities, it's providing revenue return to the territory, and it fits into a significant project designation, the toolkit is open to Tom's earlier description of the multiple layers of complexity through different agencies' legislation to be able to overarch, find where the duplication is in processes, and look for those efficiencies that you can then provide a time frame, which importantly for investors is the shortest path to getting return on that investment that they're making. So if we can bring in timeframes through cutting the red tape and reducing duplication and saving 6 months or even 12 months or more on some of these approval processes, then that's really attractive to the investors.
One final question, and it's a bit of a follow-on. Would you say with the passing of this bill, the Northern Territory would have the most competitive regulatory framework in Australia for investment?
I can't specifically answer that right here and now. I think this provides an absolute opportunity to demonstrate that we will be the best, but I haven't compared in absolute detail each jurisdiction to give you a firm answer on that here today.
Okay.
Member for Johnston.
Thank you. I just wanted to come back to something, Ms. Close, that you referenced earlier, that you said that you realised there was no need for the Territory Coordinator to make a project exempt from the Nuclear Waste Act. So I'm just wondering, it sounds like there's a very specific idea of where and when the Territory Coordinator will be using their powers. Can you list the projects that you currently have in mind?
The short answer is no, because we just don't know which projects will be designated through this approach, and the bill is there with the criteria that are in the bill about the three different types of designation to provide some criteria and scope to what those are. In drawing on the feedback and considering which acts should and shouldn't be on the schedule, we drew on a number of experiences from the past and hypothetical examples of how approval project approvals might intersect with the various acts, and therefore how the Territory Coordinator and Minister for Territory Coordinators' powers might intersect with those various acts. But there is no list of projects that we used in mind to develop that. Margaret, do you want to?
My comment is more that when you look at that act and you're looking generally at what is the regulatory framework around a significant project or a significant development, the provisions in that act, there's really no operative ones that normally would apply to significant projects of the general type that we know exist. So it's more about that act itself being for a particular purpose that does not apply to major economic developments.
Okay, thank you. That's key. So given that and given what you've just said about looking at acts, I'm wondering if you can list which NTG agencies and independent authorities you met with in relation to developing the bill. I'm happy to take that on notice.
Yeah, it's a long list because the answer would be most, but we can provide that on notice. We can.
So did you,
list.
for example, in the consultation period, particularly in the latter part of it, meet with the Aboriginal Areas Protection Authority?
I certainly personally have met with the Aboriginal Affairs Protection Authority on this at least twice.
Did you meet with the Heritage Council prior to their inclusion in the new version of the Act?
That I would have to check. Some of the consultation on this we didn't do all from the department. What we did was we worked closely in collaboration with the other agencies, including the Department of Mines and Energy that you spoke to earlier, and asked them to engage with their key stakeholders and their key regulatory bodies because they're the ones that have got the relationship and the deep knowledge to be able to have those conversations. I'd have to check.
Sure. I think we actually heard, correct me if I'm wrong, from the Heritage Council that they hadn't had the opportunity to meet with you between the first and second draft of the bill. So I think they might have given evidence of that. Thank you. Just one other question going to what you're describing and what the member for Drysdale was asking about in terms of economic development. Can you give us a concrete example of a delay that you think this will remedy? We've asked this throughout the whole inquiry, and I think we're yet to hear of one concrete example, which makes it really difficult to see the actual tangible need for this bill. Not a hypothetical.
Yeah, I'll ask Stuart to reply again. I think the same challenges around commercial in confidence and naming specific proponents will be for us as it was for Mr. Trier earlier. But Stuart, anything you'd like to add?
I'm not going to name a specific project, but I'll give you an example of a project, for example, a large-scale solar farm on a pastoral property, and the amount of approvals required for that in terms of primary and secondary approvals. There's a raft of them, including the non-pastoral permits, the water extraction licence, the environmental approvals, other infrastructure approvals, and the list goes on. All of those different pieces of legislation, for example, in various parts of it, have requirements for public consultation. This is just an example for you, which, if you look at a Gantt chart of those approvals, the public consultation will happen at different points in time and will happen over different durations in time, to the point that if you are able to coordinate the public consultation so that you're addressing the multiple layers of legislation in a one public consultation, you're saving people's time by not continually engaging on different matters, but you can save significant amounts of time in the secondary approvals being issued just by pulling back the public consultation and coordinating it. That's one example of where this could be effective in that regard.
Thank you, and I appreciate commercial in confidence. I also feel we have the weight of trying to evaluate and report back to Parliament about this law, and we've had significant evidence before us that people are feeling very concerned about the rights that they may be giving up in relation to this law, and I feel going back to them and saying, sorry, the reason for it is commercial in confidence is not good enough. I'm happy to take something on notice in a way that you could present it to us so that we can report back to the Territory who we're here, trying to represent.
I haven't, in terms of people's rights, Tom has spoken about the application of this bill. At all times, compliance with the law is required during the application of the bill. Compliance with the existing laws, even the power to step in, the Territory Coordinator can step into an agency. It cannot operate outside of the law in doing that. It still must comply with that agency's law. And in doing that, just to answer, I think the member for Gwoja's earlier question around the individual who is the Territory Coordinator not having necessarily the skills or experience, in the step-in situation, the department that the coordinator steps into, the resources and the information within that department are available then to the Territory Coordinator. So it's not making decisions in isolation of all of the information available in doing that. So we're not stepping outside of the existing legislative framework in the Northern Territory in the execution of this bill.
And that's that you in that role would receive advice, but you're not compelled to follow it. Is that right? You would still have the authority to make whatever decisions you wanted to in the role?
The role can make decisions consistent with the combination of the underlying act and this act, including the primary principle. So you can't make any decision. The position can't make any decision they like. They have to make decisions bound by the legislation that's in place and informed by the assistance and recommendations and analysis provided by the responsible entity.
Okay, thank you. So I guess just to my initial point, I would still really appreciate some concrete examples. I'm happy to take that on notice. I'm happy we could keep that confidential, but I would like to see some real examples of current unnecessary delay that this bill will address.
Just one point on that, and we will endeavour to find a way of providing something confidential that provides a bit more concrete examples. I would say that it's not just about delay, it's about coordination. So that to the point that Mr. Knowles was making around, and I was making earlier around, sometimes 15, 20, 25 more regulatory processes on top of each other and the compounding impact of them. Time is certainly a factor because if you lay those 15 to 20 to 25 approvals factors end to end, then that's a really long time. And so there's a role for that coordination in bringing that back, doing some parallel processing, collaborating across regulatory agencies so that those timeframes aren't end-to-end, so the total process is shorter. But there's also value in the reduced cost, both for the NT government and for the proponent and for external stakeholders who have an interest in that. There is a substantial cost and risk associated with that compounding of many, many processes that the coordinator can help simplify and bring more certainty and streamlining to, which has a benefit too. So it's not just about time.
I'd be happy to see example that address that as well. And just one final question, then I'll hand over.
I was just going to say, just on that point, we did, and it's just for the record, the Minerals Council did provide an example of a salt mine today that did have to move to, I believe it was WA. But I still welcome the points. Yeah.
Chair, could I just ask one final question? Yeah. I just want to note that everyone who's appeared before us has said that they support the idea of development and economic growth, and that's very important for them, and that for the community and for the stakeholders, and that they want to look at, as people on this panel, on this committee have said, for the long-term future. I understand the primary principle of economic growth. I'm interested in what you may not be able to answer this, but what your working definition is of economic growth, how you're measuring that.
Of economic growth or of economic development?
Sorry, the primary principle, which...
The primary principle has the two considerations. It has economic development and it has social economic outcomes. So you're talking about how we define economic development.
I am, yes. Thank you.
As you will no doubt have already discovered, the definition of economic development. Didn't we have a definition of economic development? It technically means what it generally means, but in terms of specifying that in the application of the primary principle, I'm not. Margaret, is that something that's come up?
So economic development is not defined in the Act or in the bill. It would be determined in the kind of the context of here and its ordinary meaning. I think what I imagine will be done, but this is a matter for the Territory Coordinator, is guidance provided around a range of things and about how factors that would be considered when determining what economic development is. I wonder, Stuart, did you have anything that you wanted to comment on about how that might be determined?
Well, I mentioned earlier, so the creation of jobs, which could be population increase, the creation of business opportunities as a result of investments flowing through. So to Margaret's point, it's not specifically defined, but the general meaning of economic development in terms of what's the return to the territory? Are we seeing a revenue return? Are we seeing population growth? Are we seeing job creation? Are we seeing infrastructure being built? That's a return to the territory.
Okay, thank you. I mean, with all due respect, it's concerning to me that the primary principle of this bill is undefined. And I think saying, you've given some examples there, thank you, Mr. Knowles, but I think saying it's the general understanding does not feel good enough to me in terms of a bill that has very far-reaching powers. So,
the member for Gwoja.
Thank you. You talk about the primary focus of this bill being coordination, but hasn't that been the role or the function of major project status and territory development? I just want that confirmed. And then, Mr. Knowles, just a question around, given we're looking at this piece of legislation, what's the reporting and accountability mechanism every time you use powers under this Act? Who do you have to report to around those activities? And then how often will that be published or presented to Parliament?
Just to remind ourselves that Stuart Knowles is the interim territory coordinator.
Well, I'm asking him as the interim coordinator. Surely he's understood what's in the legislation.
Yes, but he's not been appointed territory.
Well, I'll direct the question to you as the Deputy Chief Executive then.
So the first part of your question, I think, was about how's this different to major projects environment?
Yeah.
The big difference is that this provides an enabling legislative framework. The major projects framework never had any enabling legislation to give it teeth or the toolkit that we're talking about. So this bill provides an enabling legislative framework that provides that function with a toolkit to actually make some decisions and some directions, some requests to give effect to that coordination. To date, still the case until this bill does or doesn't pass, to date, the various teams over the years that have done major projects have relied on collaboration and the goodwill of agencies to engage and so on, rather than any legislative powers or toolkit. So that's the big difference. The second part of your question was
I'm interested in the reporting. So every time whether it's the interim or the actual territory coordinator uses powers under this Act, who do they report to? When do they report to after they've used their powers? And then will that be presented to Parliament?
Thank you, Member for Gwoja. I point you to clause 89 of the bill, and 90 that talk about those key powers, the three request powers and the three notice powers. Clauses 89 and 90 are exactly about that. The territory coordinator giving the minister a report about that request and a statement of reasons for exercising that power. So certainly the territory coordinator will need to provide the minister with that. And there is a clause 96 that says that all of those things have to be kept on a register which is made available to the public.
Sure. And are you aware of any other exceptional circumstance that may be exercised?
Exceptional circumstance for...
Are you aware of any other circumstance in which the controller may use power and not have to follow those as prescribed in the legislation?
For the key powers, which is the 6 key powers I've articulated, sections 89, 90 and 96 are pretty clear about that with no exceptions. I'd note that clause 90...
91 also.
Oh yeah, 91 is about tabling. Good point.
Yep. So the territory coordinator has to give reports to the minister after exercising the requests and the notices, and then the minister must, under clause 91, table a copy of those reports in the Legislative Assembly.
That's at the next available sittings?
Within 6 sitting days after receiving it. Yep.
Which could be a month at least. Can I just ask it's a small detailed follow-up question in relation to clause 96 and the register of information. Have you thought about how that will be made public? And I'm also curious about whether materials will be provided in First Nations languages for areas where decisions are being made that impact on people whose first language is not English.
Thank you, Member for Johnston. In terms of publicly available information, we are looking at a dedicated website where that'll be available.
Right, okay. And in relation to language accessibility for people? In particular, where decisions are being made in areas where people's first language is not English, Aboriginal languages, will there be translation available?
So that's something, to be honest with you, that I haven't got the detail on today. It's certainly something we can look at. But in terms of the exercising of the powers, there is requirement for consultation with, interested parties. So I would think that in circumstances where that's required, people in those areas being impacted, if it needs to have language translation, that would absolutely be part of that.
Okay, not so far, but hopefully into the future. I've got more questions, but if someone else can have a go.
Everyone else,
We nearly.
just
thank you. Just a specific question that the Chief Minister's on the record multiple times stating that the government's committed to the 135 recommendations from the Pepper inquiry. Can I confirm that's still the case?
That's a policy question for government, not for us as officials, I'm afraid.
All right. So you can't answer that. Understood.
You're still adhering currently, unless otherwise directed, to the 135 recommendations, yes?
Sorry?
You haven't been directed otherwise to not adhere to the 135 recommendations?
No, I have not.
Yeah.
I could keep going.
No.
Do we still have time?
Yeah, 3 more minutes.
In terms of you've talked about consultation. We've heard from several witnesses about proposals for timeframes for consultation that are and articulating that more clearly. Particularly, I think a few people have talked about making a minimum of 60-day consultation timeframe, as they are doing in South Australia. Is that correct? We've heard that. Just wondering if you have what your thoughts are on an appropriate timeframe for consultation, noting that you've said that that's one of the issues that you believe has delayed projects or made them more complex than they might need to be.
So the answer depends a bit on consultation on what.
Okay.
Because consultation frameworks for consultation timeframes are sometimes mandated in other pieces of legislation, sometimes not. As with everything, those underlying bills or those underlying acts remain valid
And
and,
they will
apply. But
sorry.
so consultation requirements explicit to this bill, is that are you talking about where are consultation requirements
Yeah.
for the
But
powers
can I
in
just
this
ask
bill?
a clarification question? So if there is, so for example, from the previous witness, if there's a consultation requirement of 90 days, this legislation, the Territory Controller could not override that. That would still be in place. Is that correct?
Unless there was an exemption notice issued for that consultation requirement, but Margaret will.
And the only way you could get rid of that would be through an exemption, and the exemption, there's only the two grounds on which you can issue one. One is that it substantially duplicates something else. So yes, potentially if, for example, if there was a requirement to consult under 3 different pieces of legislation and one of them was for 20 days, the other one's for 90 and you're trying to do it all together, you might exempt the 20 days on the balance. You've got a 90-day consultation happening over there, or otherwise the second ground is that it's not required to achieve the efficiency of regulation. So that's the only way you could do it, is under those two grounds.
And how would they be determined? Whether it was required or not? Sorry, is that question clear?
If you could explain it.
So when you say if it's determined that it's not required,
yep,
who's determining that?
It would be the minister, as only the. Sorry. Exemption notices, of course, are only issued by the minister, and it would be on advice or potentially on the minister's own consideration to issue that. Those grounds, if it was the determination that it was not required for particular reasons, they would need to be set out in a statement of reasons that would be given and tabled in Parliament.
But we've noted that there could be a significant delay between when an exemption notice is issued, for example, and Parliament gets to see it. So do you have any concerns about that?
Do we have concerns? No.
Okay, thank you.
On behalf of the committee, I'd like to thank you for appearing today. I'd like to also acknowledge all of those that we have heard from across the last 2 days of this public hearing, all of those that have made submissions, my fellow committee members, the public gallery, and those viewing both online and in person. Thank you. And also to the parliamentary staff that have been tremendous in helping making sure this public hearing runs smoothly. And then I'll close the public hearing on the Territory Coordinator Bill 2025. And thank you again.
Thank you. Thank you.